So I'm wondering, do Harvard's lawyers hire Harvard lawyers? Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube, and today I get to poke fun at Harvard. Now, those of us who have litigated against an occasional Harvard lawyer or two pretty much have the opinion that they're just not all that special other than the $3,000 suit and the shoes that would probably pay for a month's rent. But all that put aside, they're just, in most cases, not that great. I don't know why people pay $1,000 an hour for them. Truthfully, I don't. But some people do, and maybe even Harvard does. I don't know. But we have a case here today that comes to us from the First Circuit Court of Appeals, which is the Circuit Court of Appeals that's over Massachusetts. You may recall that little dust-up that started around 2014 with Students for Fair Admission, and they sued Harvard because of their race-based admissions policies. And it took them until this year, basically, to get a ruling on that case, and they did indeed get a ruling. Well, Harvard would really like to have its insurance policy pay a lot of those costs, and had a real problem with that. So one of the things that's always the case when you're interpreting a contract of any variety, but especially an insurance contract, is what does the blasted thing say? So you read it and you apply the plain meaning unless there is a defined meaning that contradicts that. So for example, business might be defined in a certain way. You might think, selling lemonade at a lemonade stand is a business, but the insurance company might not qualify that as a business, or vice versa. The insurance company might, and you might think, hey, it's my kid trying to make a little extra money to go to the pool with. But irrespective of that, insurance companies have a policy that is printed out and handed to the insured at the time the policy is issued. It has all kinds of provisions in it, and it's either going to be an occurrence-based policy or it's going to be a claims-made policy. Now, a claims-made policy says when someone makes or files a claim against the entity, then that claim filed against, you have to give notice of that to your insurer. Well, Harvard, in addition to having a primary insurance policy of $25 million, had two secondary insurance policies, one of which was with Zurich Insurance, Zurich American. Yeah, the same folks that are in the DuPont case. And no, I'm not really picking on Zurich because they just happen to show up again in this. A lot of times that kind of thing happens where, an insurer will show up 3 or 4 times. But again, I'm not trying to pick a fight with them or say they're doing anything wrong. In this case, Zurich clearly had the better argument from the Harvard lawyers. So the policy required that notice be given, and it wasn't given. Let's listen to what the Court of Appeals said about this particular issue. This is the First Circuit's opinion in the President and Fellows of Harvard College versus Zurich American Insurance Company. It's an appeal from the U.S. District Court in Massachusetts. With $15 million in coverage at stake, this case requires us to apply Massachusetts law to determine the effect of a failure to give notice as specified in an excess insurance policy affording coverage on a claims made and reported basis, where, as here, a federal court sits in diversity jurisdiction tasked with following state law. It is not free to innovate, but rather must apply state substantive rules of decision as those rules have been articulated by the state's highest tribunal. This is what lawyers refer to as the Erie Doctrine, because it arose in this Erie case, and basically it just says there is no federal common law. In this instance, the Massachusetts Supreme Judicial Court has spoken directly to the critical issue, and they cite a case here, several of them actually. What is more, this court, on no fewer than 4 occasions, has recognized the Massachusetts rule. Ruh-roh! And they have Gargano and Delugio and National Fire Insurance and JI Corp. all of these. Staying within the borders of this well-beaten path, we hold that the failure to give notice, according to the policy's terms and conditions, forfeits any right to coverage. Consequently, we affirm the district court's entry of summary judgment in favor of the insurer. Because our review follows the entry of summary judgment, we take all the facts and reasonable inferences from the light most favorable to the non-moving party. For a policy term beginning in November of 2014, the president and fellows of Harvard College, collectively Harvard, purchased a one-year liability insurance policy from National Union Fire Insurance Company of Pittsburgh, Pennsylvania, a member company of the American International Group. The policy covered litigation costs in the event a claim was brought against Harvard, as well as the payment of liabilities incurred as a result of a judgment or settlement up to the amount of $25 million. Because the AIG policy provided claims-made coverage, it required prompt notice of any claim filed against Harvard. Specifically, the policy stated, "The insureds shall, as a condition precedent to the obligations of the insurer under this policy, give written notice to the insurer of any claim made against an insured as soon as practicable. Notwithstanding the foregoing, the insured shall not be required to give written notice of a claim until the earliest occurrence of the following: the claim is or sought to be certified as a class action. Total loss, including defense costs of the claim, is reasonably estimated by the organization's general counsel or risk manager to exceed 50% of the applicable retention amount for such claim, provided, however, that in all events, all claims, including claims described above, must be reported to the insurer no later than 90 days after the end of the policy period or the discovery period if applicable." In addition to the AIG policy, Harvard purchased a secondary excess policy from Zurich American Insurance Company to insure against an additional $15 million in costs should a claim exhaust the AIG coverage. In its reporting and notice conditions, the excess policy provided, "As a condition precedent to exercising any rights under this policy, the policyholder shall give the underwriter written notice of any claim or any potential claim under this policy or any underlying insurance in the same manner required by the terms and conditions of the AIG policy." They read this and they still filed suit. Under both policies, then, securing coverage for a claim required, in all events, the reporting of that claim to the insurer within 90 days of the end of the policy period. As both AIG's primary and Zurich's excess policy provided coverage from November 1st, 2014 to November 1st of 2015. Any claim that was made against Harvard during that period had to be reported no later than January 30th, 2016. And on November 17th, 2014, an organization known as Students for Fair Admission sued in federal court for violating Title VII of the Civil Rights Act. And what preceded spanned nearly a decade and culminated in proceedings before the Supreme Court, where they reversed affirmative action. On November 19th, 2014, in anticipation of legal costs to come, Harvard notified AIG. Harvard neglected, though, to notify Zurich of the suit until May 23, 2017. Oops. Well outside the excess policy's 90-day notification period. Consequently, Zurich denied coverage under the excess policy on the ground that Harvard had failed to furnish timely notice. In September of 2021, Harvard invoked in diversity jurisdiction and sued Zurich. Harvard's complaint sought both declaratory relief and damages for breach of contract. Zurich disclaimed liability, arguing that Harvard had forfeited any entitlement to coverage. In due course, Zurich moved for summary judgment, asserting that such motion was premature and that further discovery was needed. Harvard opposed summary judgment and moved for leave to undertake and to compel production of additional discovery. After considering the parties' proffers and entertaining oral argument, the district court granted summary judgment in favor of Zurich and denied Harvard's discovery-related motions as moot. This timely appeal ensued. We review a district court's grant of summary judgment de novo. Summary judgment is appropriate if the movement shows there's no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. Because the claims under construction are in a federal court by virtue of diversity in jurisdiction, we look to the relevant state law, here Massachusetts law, to supply the substantive rules of decision. And here the Massachusetts courts generally go with the rule that an insurance contract is to be enforced according to the plain meaning of its terms. An insurer is required to prove not only that the notice requirement was breached, but also that the breach prejudiced its position. The Supreme Judicial Court has explained that this largesse is warranted because the purpose of the notice requirement in an occurrence-based policy is to afford the insurer an opportunity promptly to investigate facts pertaining to liability when that investigation can still effectively be made. Not all liability insurance policies are on equal footing, and the no harm, no foul principle does not apply to failures to give timely written notice under claims-made insurance policies. In Massachusetts, notice provisions of claims-made policies, which require that notice of a claim be given by the end of the policy period, are of the essence of those policies. And they go on to explain that there's multiple case law on that point, and where state law controls, the state's highest court has plainly articulated the law, a federal court must follow suit. So they affirmed. So I'm wondering, do you think Harvard lawyers can read, or Harvard's lawyers can read? Because it would seem to me that if you indeed knew that there was a notice provision and you didn't fulfill the notice, that you'd probably blown the coverage. And by virtue of blowing the coverage, filing a lawsuit probably wasn't going to fix that. Now, I suppose there are places in the United States where you could march into court and you're the big local defendant or the big local plaintiff, and because you have such a great deal of respect in the community, you can pretty much hope that a jury is going to side with you, and maybe you'll even get the judge to side with you. But in an insurance contract, it's the law that matters, it's the judge that matters, and juries very rarely fit into the equation. So in this case, Harvard came in, they sued, and Zurich is like, did somebody drop you on your head when you were a kid? Can you not read these notice provisions? Oh, what about these cases from the Massachusetts Supreme Court? And what about these cases from the First Circuit that all interpret this language in this very same way, that say you don't have a claim? There's a big difference between how lawyers are treated in different areas of the country, and especially if they're from out of town. Maybe these lawyers are all from M-Town, and maybe that's why they didn't wind up filing a motion for sanctions for a frivolous appeal. And it's also kind of a wonder to me that the First Circuit Court of Appeals didn't just sort of sua sponte, on its own motion, grant a motion for sanctions in this case. Because I don't believe this appeal in this case ever had a realistic chance of having any award of damages or award of declaratory judgment. But everybody's entitled to their day in court. They took it. They should have gone home with their tail between their legs, but they didn't. And that's what appellate courts are for, to resolve these kinds of issues. Today I want to remind you that one of the great privileges of citizenship in this country is to serve on a jury. Juries are important. They are the best way to determine who's right and who's wrong in a lawsuit. It's hard to get things past a jury. And yeah, sometimes you get a jury that gets hung and can't reach a decision, but that doesn't mean they don't try. I think it's really important, if you get selected or if you get notified of an opportunity to serve on a jury, that whenever you can, you take that opportunity, because you will be doing a tremendous service to your community. And that's a kindness, again, that only you can do. Thanks so much for watching. I hope you have a marvelous day, and catch me down here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys. you.